looking at punishing him for basically what he's actually charged with.
I'm not punishing him. He didn't pay for his child, so don't put it on me. If you don't pay for your children, this is what happens. This is the punishment for doing that. So don't put it on the court or anybody else.
Good morning, Judge Alan Cooper for Juwan Crawford.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Your Honor, I've discussed the matter with my client. He's agreeable to waiving the preliminary exam.
Your name, sir?
Juwan Crawford.
And you're going to waive your preliminary examination?
Yes, sir.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the 2 counts.
Your Honor, may I address the issue of bonds again?
Well, let me do the arraignment and then I'll do that. Do you acknowledge receipt of the information, waive its reading?
Yes, Your Honor.
And at this time, your client stands mute?
Yes, Your Honor.
Defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea. I will set circuit court pretrial for
March 2nd at 1:30 with Judge Simpson.
March 2nd, 2026, 1:30 before Judge Hammoud. Yes, that's the bond.
Yes, Judge. I made this request last week as well. My client, unfortunately, he had a difficult time with his employment over the past 2 or 3 years. He was injured. However, he has been seeking employment. He actually does have a job offer letter substantiating that he's got a job waiting for him. Now, that letter is from a company called Real Truck, indicating that his start date was actually supposed to be the day before yesterday, but he thinks that if he follows up with him, he might still be able to get this job underway, which is obviously significant because the whole crux of this case is to get some kind of payment schedule. If he's not working, then he can't work out a payment schedule with the prosecutor. So I understand that there's been some non-payment over the past year or so. That's because he has been unemployed, but now he actually does have employment. He's trying to properly put this matter behind him. So I think the fact that he actually does have a written job offer is good cause to reduce the bond. I would like a personal bond because that's all he can afford. The family is in court. There's no risk of flight. He's got 5 brothers and sisters. All of them have tried to talk and try to compile some, even the 25%. None of the family members can come up with this. So it's going to be up to Mr. Crawford to actually try to get payments to work something out ultimately when he deals with this felony child support case. So because he's got this job waiting for him, it's solid, it's confirmed, it's in writing. I would just ask that the bond be reduced to a personal bond, and let's deal with the matter at circuit court.
Are you saying the $25,000 that was listed on the complaint was only non-payment for a year?
Yes.
Is that what you're indicating, counsel?
Your Honor, I didn't do all the math on it. I think his support was set at about $1,200 or $1,500 a month.
Yes.
And I'm not sure if it was for 1 year. I think it was over a period of 2 years, or maybe a year and a half or so.
I mean, the difficulty is that the statute, I mean, I hear your argument, but the statute very clearly dictates 25%. I'm not sure that a job offer, and this court wouldn't find that a job offer in and of itself is going to constitute good cause. But
otherwise than what you're doing, then you're looking at punishing him for basically what he's actually charged with.
I'm not punishing him. He didn't pay for his child, so don't put it on me.
Well, in effect,
if you don't pay for your children, this is what happens. This is the punishment for doing that. So don't put it on the court or anybody else. The legislature made the statute. It says 25%. I'm not punishing him for anything. If he doesn't meet the standard of good cause, he doesn't meet the standard of good cause, counsel. Do I have a response from the people?
Yes, Your Honor. I would agree with you. We would ask that you deny modification of the bond specifically to a PR bond. Again, as stated last week and as stated today, lack of payment, promise to pay, to me, in my opinion, is not good cause to modify the bond. while the defendant was out and free and not under course, not incarcerated, he had the opportunity to pay. The amount that accrued is now at over 32,000, and that was over a few years. So we have no guarantee that just releasing him and him seeking a possible employment opportunity will guarantee payment. And for those reasons, Your Honor, we would ask that you deny modifying the bond today. Thank you.
This is nothing different than I heard the last time that he was here. And quite frankly, the court in it would be of rights to up his bond because the amount is now higher than it was in the complaint. But I'm not going to do that. I'm going to leave it where it is at this point. But I'm not going to find that there's any good cause. Once again, motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
The defense has already surrendered one procedural checkpoint by waiving the preliminary examination, but that is not an admission of guilt. It simply means the prosecution will not have to establish probable cause at that hearing, and Crawford moves directly to circuit court on both counts. The real dispute here is bond. Defense counsel ties release to the job offer, employment could produce income, income could support repayment, and family ties allegedly reduce flight risk. Strategically, that is coherent, but Judge Simpson identifies the missing link. A written offer with a missed start date does not prove Crawford will begin work, make payments, or satisfy the statute's good cause requirement. Did you notice counsel also appeared uncertain about whether the arrears accumulated over 1 year, 18 months, or 2 years? That uncertainty weakens a request built around financial hardship. The prosecutor then supplies the damaging comparison. Crawford allegedly accumulated more than $32,000 while free, so liberty alone did not previously produce payment. Judge Simpson's refusal to increase the bond shows restraint, but leaving it unchanged signals that promises about future compliance need corroboration, not optimism.
Court calls case, People versus Stephen Javon.
Edna Gurma. Ms. Gurma, please state your full name for the record.
Excuse me, Edna Joy Gurma.
Thank you. What are we doing?
Respectfully, Your Honor, I just got appointed to this matter. We're going to ask for.
And you're not ready? No, go ahead. I'm sorry. My bad.
We're going to ask for adjournment on this matter.
All right.
I'm going to have to turn in my green sheet.
You don't have it?
I don't.
What have you been doing? Besides, never mind.
Don't do me like that. Don't do me like that.
Probable cause conference. I'll just adjourn it out in 2 weeks, let you get caught up and do that. Okay, Ms. Gurman?
Gotcha.
March 5th, 2026, 90.
And permission to address bond, Your Honor.
Yes.
Respectfully, my client did have she did Prop 30. She doesn't want to make any excuses why, but she wants to move forward and knows that she can move forward. She's 61 years old. Been through a lot in her life, but she is trying to make things right. She has a Stop the Gun Violence Outreach program that she's preparing for in June that's sponsored by the Ypsilanti, sponsored by the city of Ypsilanti, in which she's the administrator for and makes a lot of things happen for that. She understands that she needs to work at it. She does have meds that she's not receiving right now. She does have a therapist that she goes to when she's out there for some mental conditions that she suffers from. And she did put in a referral for Down Farms and mental health, in which she told me that
for Down Farms and mental health too.
No.
Go ahead.
Okay. The Washington mental people gave me an intake.
For Dawn Farm.
Yes, sir, for the outpatients on Gulfside.
All right. So respectfully, Your Honor, we're just asking that is why is an honorable court give Ms. Gurma a chance. No, give her a second.
Wise nor honorable.
Wise.
Go ahead.
Give Ms. Gurma a second opportunity, and she will prove to this court that she can abide all bond conditions.
Yes, sir.
Any response from the brief?
Judge, I believe that you changed your bonds because of contingency use.
Yeah.
And what she's doing in the jail is admirable, and I think that she can get started in the process.
What I'm going to do, just listen to, I'm going to deny your request. However, I will sign, if I have not, a release to treatment. Okay. What's wrong, Ms. Gerber?
This will be our 5th event,
I know.
and it's in honor of my nephew who was killed on Thanksgiving in 2021, and all gun violence families, survivors, and the community.
But hold it. Maybe you're not hearing what I'm saying.
Shut up. I'm gonna shut up.
No, you can talk to me. I don't have a problem with that. The release to treatment I'm not saying that it has to be inpatient treatment. I'm saying she can be, but she's gonna have to be released to treatment. It sounds to me like you started that process. So if we can get that all worked out, I'm not gonna have a problem with that, because that's really what you need. And although you're trying your best, you can't do that on your own. That's just the reality. And you know that as well as I do. Okay?
Okay.
So, counsel, if you get me a release of treatment order, I'll sign it.
All right, thank you. Thank you, Your Honor.
All right. And for her, it can be inpatient or outpatient treatment, but I want something structured around her before I'm even going to consider releasing her for whatever reason.
All right, sounds good, Your Honor. Thank you.
Thank you.
Judge Simpson has drawn a crucial distinction between an ordinary bond reduction and a structured release into treatment. Jerma's age, community outreach, mental health treatment history, and planned gun violence event are meaningful mitigation, but none directly proves that she can follow bond conditions without additional support. Even the prosecutor acknowledges that her work inside the jail is admirable. The judge's concern, however, is risk management, not whether she has done good things elsewhere. Notice what happens when Germa interrupts to explain the importance of her event. Judge Simpson initially stops her, then clarifies that she may speak and redirects the discussion toward what she actually needs. Her emotional investment may be genuine, but the court cannot substitute sincerity for a workable release plan. Would her community role alone convince you that the underlying problem has been stabilized? By authorizing either inpatient or outpatient treatment, Judge Simpson leaves flexibility while insisting on accountability. Defense counsel now has a clear strategic assignment: secure a program, prepare the release to treatment order, and show that supervision will begin immediately. This is not a denial without hope. It is a conditional pathway, but until that structure exists on paper, the judge is unwilling to assume it will exist in practice.
And good morning, Your Honor. Joseph Paul appearing for and on behalf of Ms. Hunter, who is approaching. Ms. Hunter, when you arrive, could you state your name for the record, please?
Lucretia Honor.
Hold it. Were you here? You're in this block too?
Yeah, Judge. I can stick around all day if you know.
Why are you threatening?
Your Honor, on this matter, we've very recently retained. We have received the police report, but we're awaiting further discovery of the adjourn date for PCC.
Probable cause conference, March. Hey, remind me, what did I set your other ones?
I believe
the 12th or 19th.
We have one on the 12th.
12th. March 12th, 2026, 9 a.m.
And Your Honor,
I don't know why I'm being so courteous today.
I appreciate it though,
no,
Judge.
But it's really throwing me off. I feel that way.
Well, continuing that, Your Honor, to ask Your Honor.
Now you're going to mess it up.
I probably am. Your Honor, I'm going to bring up just one part of bond today, Your Honor. That is that Ms. Hunter is currently wearing a tether. It's a GPS tether.
Mm-hmm.
She's got a 16-year-old at home. She's a single mother. She's 37 years old with no prior record of any kind.
Put the tether on the child.
What's that?
Nothing.
You never want to offer that to a parent of a teenager, Judge.
Yeah.
But it's interfering with a lot of parts of her life. She has not violated in any way since that thing was imposed. She has no interest in seeing the alleged victim. and doesn't really have some pre-existing relationship with this person.
Bruce Robinson, people.
Your Honor, we'd ask Tether to remain. I do know something from the odds where there was an egg assault conviction. But
For
this is an incident.
an egg assault on.
By this, the defendant has a conviction from 2008 or 9. So it's older. The reason I would request Tether stay is this appears to be an incident that also involved various former and current relationships and overlays with all of that. So I think that keeping them apart, knowing, giving the victim peace of mind is important. We have a chance to contact the victim regarding that.
On information and belief, an ag assault was thrown out in the aughts. So I don't know if that's challenged anyway.
That's fine.
But
it's 8. I was like 12 when that.
And so Your Honor, and these connections are alleged to be with the defendant's sister, not the defendant. So she really has no overlap unless you go through family and other things. She knows where the lines.
Who is this person?
This is
in
a
relation
person
to the alleged victim is whom to this defendant?
So the alleged victim's baby's father was allegedly sleeping with the defendant's sister, which caused the alleged victim to go to the residence of the defendant's sister. And this incident arises.
She happened to be there,
and
she's at her.
But we don't want to.
The defendant may have been at her sister's place. Then this person comes there.
Yes, that's on information and belief, Your Honor. That's all correct. There's no allegation of seeking out.
Other than that,
that's it, Judge.
Is there any other connection that this individual would have with this person?
None whatsoever.
And she's got a GPS teller, so it's not even it's not even one that has an exclusion on. It's just a GPS tracking where she's going.
I believe that's correct. There is a no go-to here.
Right, there's a no go-to, but I mean,
I don't want to speak out of turn, Your Honor. I do not.
No, I got you, and I realize you just got into this.
Some GPS studies have what's called an exclusion zone.
My notes from the arraignment show an exclusion. GPS teller was an exclusion.
Yeah. No.
I'm going to continue the defendant's bond. However, I'm going to remove the GPS teller. I don't. If circumstances such as that, I don't see a need for.
Thank you so much, Your Honor.
You'll, I'm sure, inform your client. Don't give me reason to put it back on or incarcerate it. Right?
Very clearly, Your Honor. Thanks again.
Yeah. Well, yeah. So that there's an order to go over there.
Take care, Your Honor.
Thank you.
Thank you.
Anderson.
Assistant Public Defender Jay Dollinger on behalf of Ms. Anderson on cases ending in 5640 and 5026, Your Honor. We're also aware of the bond violation this morning.
Yes, Your Honor. Brandon Bird on behalf of Bryce Anderson on the case ending in 5330.
And Ms. Anderson, can you please state your name for the record?
Bryce Anderson.
And Your Honor, as to the PCCs on this matter, we would be asking for an adjournment. I have spoken with the prosecutor. He's looking for a mitigation on this, which I'm happy to draw up, but that will take a few weeks.
Here, Your Honor. All right. So you want me to adjourn that and the bond violation, or?
Your Honor, after speaking with our client, it's my understanding that she is willing to plead guilty to the violation this morning. We do have an explanation.
adjourn to probable cause conferences then will the 5th be enough time for you to get done what you need to get done, or do you need the 12th?
I would need the 12th, Your Honor.
Adjourn these to March 12th, 2026, 9
I'm gonna come meet with you so we can.
As to bond, I guess, the court having accepted her plea guilty to the violation.
Respectfully, Your Honor, our client wasn't able to get in the house in which she was living. So her tether died. Am I correct?
Yeah. Our understanding is that she has a roommate, Your Honor. Her roommate locked her out of the house. Her phone was in the house. Her tether died. She wasn't able to get back into the house and charge it. She does apologize to the court for the violation. She really had no way to do it. As to the missed test, Your Honor, again, she didn't have a phone at the time. She couldn't call.
Did she not have the charger? Or
she did not have the charger that was in the home.
Did she go to community corrections?
She did not, Your Honor. She had no way to get there, and she otherwise would have called them. However, her phone was in the house. Is that correct as well? Okay.
Well, what actions did she take to try to get it charged?
I just tried to get back into the house, and I just tried to talk, try to find it, try to have her give me the charger or throw it through the window or something, and she wouldn't let me in.
Where was the house was located? Where?
It was the one on Packard. It was the apartments on Packard.
It's a pretty tumultuous relationship with the roommate, Your Honor.
Okay, I get that part of it, but I guess what I don't understand, if she's on Packard, why she didn't just walk over to community corrections.
I honestly didn't even know I could have just come over and just said like, hey, I didn't have the charger. I really just didn't know that. I rather was trying to get it.
Well, where is the charger now?
Still in the house.
So if I were to let you out, where would you? Well, first of all, you didn't appear was one of the things. Why didn't she appear for the hearing?
Your Honor,
the last hearing, the jail did say that my client wouldn't come out the cell. Now, after speaking with Miss Anderson, Your Honor, she's been very polite to me. She has been very polite, and I believe we're able to work together now to get some of those issues handled. That's one of the reasons why we're trying to put in this mitigation report for mental health issues. My client does suffer from mental health issues, Your Honor, but she understands that she has to show up to court. She understands where she doesn't want to be at this time.
Okay, when she's locked out, where was she then? And when she was locked out, where was she?
I was on Packard.
What did you do when you were locked out of the house? You were still at the house?
No, I ended up going over to my godparents' in-laws. I ended up going over there and staying over there for a minute, and then going back to my apartment every day trying to get into the apartment. And that's where I got arrested.
Okay, so when you went to your godparents, did you ask them to give you a ride to community? I mean, I guess I'm not understanding.
I never thought to come up to community corrections because I have to call a number, right? You can't just come up. You have to call the number, and the number says your number or color, and then you come up. But without my phone, then without the charger, I just didn't do it. I never thought to just pop up and come up. I didn't think to do that. It just wasn't in my mind to do that. I get what you're saying, but I just really honestly didn't think to do it.
Your response?
No objection to a release for treatment, but I do have concerns for this defendant's own well-being. On the new case, the 26 case, in that report, the defendant indicates she attempted to harm and kill herself using drugs. So I'm concerned that when you don't have testing and there's this prior history of attempts to use those drugs to commit self-harm, we might not see this defendant again if released on her own without any sort of supervision. So I think release to treatment would be good and appropriate, but otherwise I would ask.
Would you be okay with a release to treatment? Is that something you want us to?
Yeah, right.
Okay. Your Honor, after speaking with my client, it's my understanding that she herself would be okay with the release to treatment. So I'm happy to submit an order to the court.
All right. So what I will do is
I can submit it on your case too.
I'm gonna continue her bond at the amount it's at.
I'll get that
They'll
done.
sign once presented to me in order to release to treatment.
I'll include you on the email.
I'll also adjourn the sentencing on the violation to the March 12th date. So I'm not going to sentence her on that. I'm just going to leave everything where it is. We'll get the order. If she can get released to treatment, that'd be great. I think that might be the best thing.
Okay, thank you very much, Your Honor.
Thank you.
Okay, I'll be in touch, okay?
All right, thank you.
Judge Simpson's final ruling balances accountability with immediate safety. Anderson has admitted the bond violation, so the court is no longer deciding whether non-compliance occurred. The question is what response is proportionate. Her explanation, that a roommate locked her out with her phone and charger inside, accounts for how the Tether died, but it does not fully explain why she failed to seek help, walk to community corrections from Packard, use another phone, or appear as required. Notice how the judge repeatedly tests alternatives rather than accepting the first explanation. That is a credibility check. When someone claims there was no way to comply, the court examines whether reasonable options were actually exhausted. The prosecutor then shifts the analysis from punishment to protection, citing the report's account of attempted self-harm involving drugs and supporting release only into treatment. Defense agrees, which gives Judge Simpson a controlled alternative to unconditional release. He continues the existing bond, postpones sentencing on the admitted violation, and agrees to sign a release to treatment order once it is presented. That preserves leverage while creating a path out of custody with structure around Anderson. Across this docket, the pattern is consistent. Promises alone did not earn Crawford a reduction. Treatment structure created a possible release route for Germa and Anderson, and Hunter obtained relief only where GPS appeared unnecessary. Would you call that strict, measured, or both? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.